Hey everybody, Jason Burmis here. And here's a story that I should have broken, but I did not read the entire document and I didn't read it thoroughly enough. What am I talking about? Well, earlier in the week, if you've been tuning in, I discussed two documents that came out, one of which had to do with Ghislaine Maxwell and Virginia Giuffre Roberts and judicial documents. And basically throughout this, Ghislaine Maxwell and her lawyers are trying to keep sealed those 10,000 plus documents. In fact, we're going to read this because I think it's important. Throughout it, she continues to play the victim. Now, I just want to say right now that I don't know that Ghislaine Maxwell's emails were ever hacked. What do I mean? Well, let's be really clear right now. The 10,000 pages that we're discussing have nothing to do with the hacked emails themselves if they were indeed ever hacked. This could be a lawyer ploy. And it could be a great opportunity for disinformation tenfold in many different manners, and I'll get there in a minute. What do I mean? Well, with the 2,000 page data dump, the 2,000 plus page data dump that we went over many of the revelations, the Glenn Dubin, the George Mitchell, the Richardson, the Governor Richardson of New Mexico revelations being named as some of these alleged pedophiles and people that basically had young girls pimped out to them. And remember, New Mexico is important because of Zorro Ranch and the fact that Epstein never had to file as a sexual predator there at all. That's how they set that deal up, okay? So what are we talking about here? The lawyers are claiming that because the judge allowed those 2,000 plus pages, there was an instance which they did not redact Ghislaine Maxwell's email address, which was not like a Gmail or a Yahoo account, and it was on one of her own private servers. They're claiming that that private server and her actual emails were indeed hacked, and now each document has to go not only be gone through thoroughly, but now all of these other documents are out in the wilderness. Now remember, it's her lawyers claiming that these emails could be hacked. Now just putting this out into the public, people could doctor emails, put them on message boards like 4chan and 8chan, cause a big stir and cause disinformation and other credible people to be, discredited and real information to be discredited. Because if you don't think that there is a purposeful campaign to try to not only obfuscate the truth, but put full-on disinfo out there, you'd be completely mistaken. 100% there is. And by the way, thumbs this video up, sub, and share if you're new. So what I want to do here is, again, if you look at the story, they're basically talking about the 2,000 page data dump here. You can get down and we're going to get into the quote where it says hackers obtain that. Where is it? Let's see. As another example, it redacted Miss Maxwell's email address, which linked to her own domain name in one location but not another. Shortly afterwards, hackers breached the host computer. But again, this is Ghislaine Maxwell's lawyers claiming this. Let's just read the document because, again, she's the victim. She's the victim, guys. We should all be very upset for Ghislaine Maxwell. Dear Judge Preska, paragraph 1 of the court's October 28th order required the parties to identify motions decided by the court and related papers that were sealed or redacted. Paragraphs 3 and 5 required that any party contending a sealed material should remain sealed or redacted, submit a letter brief providing the reason such material should remain sealed or redacted. On November 19th, the court said the proponent of continued sealing redaction need only state the reason in summary fashion. I mean, again, these are a huge amount of documents. And one by one now, They will be decided whether they are judicial in nature or not judicial. And remember, she's a victim because they forgot to redact her email address, and now her private computer's been hacked. The difficulty and complexity of the project before reaching the merits of sealing redaction of the sealed materials, we think it appropriate and necessary to address the complexity and difficulty of the project, as well as its difficult to overstate importance to the lives of Miss Maxwell and non-parties. Yeah, there's a lot of fucking important people we're covering up for. Don't you get it, Judge? The volume of sealed materials is substantial. Yes, it is. The sealed materials contain motions, responses, replies, 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 memoranda, correspondence, declarations, exhibits, notices, and orders. Depending whether the materials were filed under seal, each motion, response, etc., occupied a separate docket number. We estimate we reviewed more than 600 docketed materials, totaling more than 8,600 pages. Now remember, these are complete. This is just the Virginia Giuffre Roberts Ghislaine Maxwell case. They're completely separate from the files that were sealed by the cover-up crew in regards to the Victims' Crimes Rights Act, the Victims' Crimes Rights Act, and the fact that he got that sweetheart deal. Remember, they said there wasn't one scintilla of evidence that Epstein got a sweetheart deal. And remember, Acosta said at one point, he wasn't going to get any jail time. That's what a grand jury said, that a grand jury had seen the information. He wasn't going to get any jail time. That's real. I went over that months ago. That was well before Acosta gave that press conference. When I think it was either Catherine Clark. In fact, I'm almost sure it was Catherine Clark who asked him that question. This project could not be accompanied by scanning or speed reading. For redacted materials, there were many documents where there was only a single item on a page was redacted, e.g. a surname or an email address. There were other documents where on a single page, various phrases, sentences, or paragraphs were redacted. To determine whether redaction was warranted, context was important. We were required to read each word, line, paragraph, and page of the sealed materials. For reasons having to do with the legal basis for sealing and redacting non-judicial and judicial documents discussed later in this letter, this was not a project that could be performed by non-lawyers or by lawyers who did not have the familiarity with the lawsuit. Only certain lawyers will do, including the plaintiff's counsel's litigation tactics, plaintiff's allegations, and Miss Maxwell's privacy interests. Privacy interests. Wonder if those have anything to do with the intelligence ties we've been reading all about. Or the ties to people like Weinstein or the Clintons, those type of people. Or even Trump, right? There's plenty of pictures with him. Further complicating the review are the numerous and varied legal grounds for sealing and redacting non-judicial and judicial documents. Two general grounds exist. A document may be sealed if it is a non-judicial document, or if it is a judicial document which implicates a person's interests that outweigh the presumption of access afforded to that document. Let me translate that for you. If by chance you rule this thing a judicial document, we're still going to handpick and select what we redact on behalf of powerful people. That's what that means. That was lawyer speak for that. Thumbs this video up, guys. As the Second Circuit's jurisprudence discloses, it is not always clear what is or is not a judicial document. Yeah, you want to cloud the waters. You want to redact and withhold as much as you can. And that's why, again, guys, remember, lawyers are liars. Are they going to prove that this was hacked? How do we know that after that document went out, supposedly, out of the 2,000 pages, and it was hacked, they didn't do the hacking on purpose to make the argument? You got to watch the disinfo. The Second Circuit has declined to limit the universe of interest that may be advanced to rebut the presumption. I'm not even going to get into that. We have identified at least 12 applicable to Miss Maxwell in this action. Those reviewing the sealed materials on Miss Maxwell's behalf, therefore, were required to determine, while reading the materials, the weight of the presumption that should be afforded a particular judicial document, and whether one, two, or as frequently with this case, numerous interests could be identified sufficient to rebut the presumption of access. So now we're not even talking about individual access. So in other words, it's not just somebody, their interest, like a president or a prime minister's interest, but maybe an organization's interests, like the FBI and their cover-up of this, or maybe the Central Intelligence Agency and working with them, or possibly the Israeli Mossad that's been named many times in this case. Think about that. Numerous interests could be identified to suppress this information. The three counsel of record completed this project within the time constraints imposed by the court in this expedited proceeding. That is not a complaint or an excuse, simply the reality that informs the product of our work. We have no doubt that we failed to see all the redacted words, phrases, sentences, and paragraphs that should remain redacted, and that we failed as to each redacted or sealed material to identify all the interests supporting continued redaction and sealing of a material. It could not be otherwise, given the time constraints and human limitations. So let me translate again. Only certain lawyers can work on this and see this stuff. We're the cover-up crew. We need more time. Don't you get it, Judge? You have to rule with us. We speak from a shared experience. The Second Circuit released some 2,000 pages of sealed and redacted summary judgment materials. Before releasing the materials, the Second Circuit panel did not request review by the parties, did not hold a hearing, did not notify the parties which of the 2,000 pages would be unsealed and unredacted, and did not specify what words, phrases, sentences, or paragraphs it would be redacting. Wah! They released information we didn't want them to. Wah! We can't let that happen again. Instead, the panel said it was redacting personal phone numbers, contact lists, birth dates, and social security numbers, and the names of alleged minor victims of sexual abuse from deposition testimony and police reports, as well as deposition responses concerning intimate matters where the questions were likely only permitted and the responses only compelled because of a strong expectation of continued confidentiality. These criteria, the panel said, led to only minimal redactions. Remember, there was still redactions there. I complained about that. And although some of them were there, it seemed to protect victims' names or even associates of victims that they interviewed. That was another thing. I felt that it was overly done. But of course, they're arguing the other side of that. They wanted more. The panel apparently did not consider any countervailing interests other than the parties' and minors' privacy interests. Yeah. And I think in certain cases, they still were over the top. Despite the Second Circuit's best efforts, it made serious mistakes. For example, it redacted a non-party's name in one location but not another. So the media immediately gained access to that name. Oh no. Oh no. A non-party's name. Oh no. As another example, and this is the fishy part, remember, it redacted Miss Maxwell's email address, which linked to her own domain name, in one location but not another. Shortly afterwards, hackers breached the host computer. So again, that's a huge implication. That once they say that the hackers breached that computer, they could say that all those emails or information that was on there, other than emails, could be sold to somebody, right? It gives grifters the opportunity to point to fake posts or fake emails, fake leaks, right? Or it also, remember, you had that one guy that went to David Boies and other lawyers and said he had video of Dershowitz, he had access to online servers, all of which seemed to be a disinfo op. Okay, and now it's in the court records. It would be hard to overstate the media's interest in this case. By media, We include all constituents of the 21st century media, established newspapers and broadcast media, internet publications of every kind, bloggers, hackers who publish on the internet, that's ridiculous, social media users, and everyone who owns a computer, tablet, or smartphone who distributes information to others. Yeah, they don't like a guy like me actually reading you these documents. That's what that lawyer speak was. Because let's face it, the media usually doesn't do a great job with these things. They don't, not the mainstream. There are exceptions. The lawyers for the parties and non-parties have received hundreds of emails and telephone communications and inquiries. Some of the parties, including plaintiff Ghislaine and other plaintiffs and their respective lawyers and public relations consultants, have stoked and are actively stoking media interest for their own ends. As they should, you fucking monster. As they should. Again, when you have the police in the Virgin Islands suing the estate of Jeffrey Epstein, alleging that he trafficked in children as young as 11 throughout 2018 after his sweetheart deal. Thank God these women are coming forward. Thank God there are people out there on the web reading these documents, stoking interest in the public. That's a good thing. Miss Maxwell has not sought out any media attention, and for that she has attracted more media attention. No, it has nothing to do with the fact she hasn't sought media attention. It's the fact that she's not in fucking jail. That's the problem. That she's not in jail with her co-conspirators. That's the issue. London's tabloid The Sun placed a 10,000 bounty on Maxwell's head, ooh, dangling its checkbook, to encourage anyone with information on her whereabouts to come forward. As they should. Your client is a criminal accused of some of the most abhorrent crimes you can imagine. Vanity Fair reported now perhaps Maxwell is the one who needs to be looking over her shoulder. That is for reporters lurking in the bushes, ready to pounce with voice recorders and cameras in hand. In recent months, journalists have searched high and low for Maxwell, who had already been maintaining a low profile even before the Epstein scandal came roaring back to life this past summer. Correct. So here we go, more lawyer bullshit. There is no doubt that every word, phrase, sentence, and paragraph of any document disclosed to the public will be scrutinized by members of the media with as much diligence as we have. Good. With the exception that they have no time limit. That's not true. And depending on the media member, with an economy of ethics. Oh, you're the ethical one. The lawyers are the I'm sorry. They're the ethical one. And when they say there's no time limit, listen, our time was already up. Don't you get it? Epstein is dead. Okay? We didn't put anybody else big time in jail. We're fighting to get documents in a civil suit. The cover-up crew is in full effect. Bill Barr is telling you he killed himself. Okay? And don't get me wrong. There's hearings going on in relation to the quote-unquote first suicide attempt. There's people protesting by putting up plaques of Alan Dershowitz on the 71 Street mansion in New York. I mean, there is activism. I mean, the Once Upon a Time in Hollywood stuff, that was great stuff. People are waking up to this. But these demons, they don't want you to. For these reasons, we respectfully request that before ordering the unsealing or unredaction of any of the sealed materials, the court notify us and the affected non-parties of the docket numbers it intends to disclose, that so that we can conduct a second review of the materials. Under the circumstances, we also request that as to any material to which we have lodged an objection to unsealing or unredaction, the court allow us to preserve the right to assert additional reasons to continue the sealing redaction that we were unable to identify in our initial review of these thousands of pages of documents. In other words, if we done fucked up and we didn't find out that this was a document we didn't want to in the public arena for any reason, we're going to need time to give you another argument to keep that sealed. Because we're lawyers. We lie for the devils of the world for money without ethics. But guys like me, you got to worry about because, I have access to the internet and the documents now, and I'm not ethically trained like a lawyer. Thumbs the video up, sub and share if you're new, guys. This is how we do it. We read the documents here. We do it live. The reasons for maintaining the redactions of the sealed materials. Because of the volume of sealed materials, we prepared a spreadsheet attached, which we don't have, by the way, which for each docket number states whether the filing was sealed or redacted, provides the titling of the filing, and provides the reason it should remain sealed or redacted. The reason given is one or more letters, A, B, C, D, and so on, that correspond to the following legal grounds. So here we go. Privacy. A person's privacy interests are sufficient to overcome even a heavy presumption of access afforded to a judicial document. So this is after they already figured out that it is indeed a judicial document, but we just want to keep it private because the person is powerful. Okay? Is powerful. Ancillary court submissions. A court's authority to oversee discovery and control the evidence introduced at trial is ancillary to the court's core role in adjudicating the case. In other words, they want to limit the documents you get that pertain to the discovery in this case. Cover up fucking crew. That's what this is. Let's keep going on. Reasonable reliance on a protective order by a party or non-party. If a party or a non-party provides information in connection with a lawsuit, reasonable reliance on a federal rule of civil procedure. So in other words, they can just lawyer you to death. If there are certain cases that are open that may be harmed by some of these documents coming out, they're going to make the argument they shouldn't. Okay? See that? A strong expectation of continued confidentiality. Prevention of the abuse of court records and files. So this is where they're really talking about, whether or not these are judicial or non-judicial, and they are going to be used to gratify private spite or promote public scandal. Promote public scandal? Hey, maybe you shouldn't have trafficked in fucking kids, you monster. Are you fucking kidding me? Serve as a reservoir of libelous statements for press consumption. E, annoyance, embarrassment, oppression, undue burden. Oh, it's going to... Are you looking at this? This is joke world. Oh, I'm sorry if you might be embarrassed by the fact that you sexually assaulted Maria Farmer back in 1996 with Epstein while she worked the door for you. Well, you had underage models coming in that you refer to as nubiles. It might be an annoyance for you that I'm pointing that out and the FBI did nothing and the NYPD did nothing back in 96. That might be an annoyance and embarrassment. But is it really undue burden on you, Miss Maxwell? Am I oppressing you? I think not. Redundant, immaterial, impertinent, or scandalous material. So again, they're trying to lump in scandalous material with redundant material. Think how insane that is. Preserving the fundamental rights of suspects or others under criminal investigation. Oh, we need to preserve their rights, right? Just like in Ireland, they don't need to name Conor McGregor as the violent, brutal rapist who almost killed a woman while raping her. And then in this country, they just won't mention any of the details when they do name him under their breaths. Because we need to preserve the fundamental rights of those suspects. It's the world we live in, man. Protecting criminal investigations and the privacy and safety of witnesses and suspects in criminal investigations. Guys, just so you know, I want to believe that has anything to do with it. It doesn't. These criminal investigations go fucking nowhere. It's the cover-up crew. Look what happened in Palm Beach. Look at a guy like Anthony Weiner, who serves a small amount of time, comes back to New York, and now he's going to get into the legal marijuana business. Look at a guy like Dennis Hassert. Never spent a day in jail for abusing children, labeled a serial pedophile by a judge. Look at the former Seattle mayor, Ed Murray, and the numerous accusations against him, going back as far as when he was in high school. These are real things. So when they're telling they want to redact names to protect people in criminal investigations, they're fucking full of shit. They literally just covered everything they possibly could because they're lawyers on behalf of demons. Other interests. Courts have found that interests such as a protection on ongoing investigations, safety of witnesses, national security. Notice national security is in there. And trade secrets may be sufficient to defeat the presumption. Why would you need to put national security in here if they're not in part of intelligence whatsoever? If you're not protecting the powerful, if you're not protecting the Clintons of the world, the Hood Baracks of the world, the Richardsons, the Dubins, the Mitchells, the Prince Andrews, if you're not protecting them, national security in here. Come on. Let's keep going. Untrustworthy, unreliable, and incorrect information. Oh, we're worried about that. We're worried about hearsay. These guys are the kings of misinformation and disinformation. All right? Expectation of continued confidentiality. Now remember, they cut these deals in Palm Beach, so they're going to make that, they cut deals for all these unnamed people. Improper submission of documents, any kind of technical issue, and then M, non-judicial documents, okay? They're saying that the mere filing of a document doesn't make it sufficient. So there you go. There's the whole thing. Remember, the hacking thing could be complete disinfo put out by those lawyers. They could be setting us up for something big. Guys, make sure you thumbs this video up, subscribe, and share. I also have been doing this thing on Rockfin 5 days a week. Exclusive videos. You can sign up over at Rockfin for free and follow me, and there's some free stuff on there as well. But 5 videos that you're not going to find on YouTube per week. Things we can do there that I probably can't do here. For instance, if you check it out, I streamed some of the impeachment hearings live with live commentary. Probably can't get away with that on YouTube. So we're utilizing this as a platform that allows me to do things that I can't do elsewhere. It's $9.99 a month if you want the premium content, but that's not just for Jason Bermas's content. This thing is MMA heavy, real wrestling, not pro wrestling heavy, free thinking media. If I go over to free thinking media, and by the way, you want to hit that endorse Jason Bermas button. You got Nico House, you got the Convo Couch, you got Graham Elwood, Placone's on here. But hey man, this is a platform that is diverse and it's actually promoting my material. Can you imagine that? So if you want to support me, that's one way to do it. Again, make sure you thumbs this video up, sub and share 3 to 7 times a day. We're doing these videos on YouTube. I'm a documentary filmmaker. They're all free right here in the documentary playlist section. Loose Change, Final Cut, Fabled Enemies, Invisible Empire, A New World Order to Find, and Shade the Motion Picture. And guys, I truly can't do it without your financial support. So $5, $10, $15, it means the world to me. Those of you like the Ryan Ericksons of the world that throw me $100 and Candace Gavin that throw me $50, they really make this possible that I can drop this knowledge at 2:30 a.m. on a Wednesday. So we do it live, we do it hardcore, we go beyond that left-right paradigm that's just total and complete bullshit, and we expose the truth here. I love you guys, and I will absolutely see you on the flip side.